They've got health information, they've got racial and ethnic origin, which is quite sensitive data that you need sort of a better legal basis. You need a different one. You can't necessarily rely on consent, for example, in the employee context. And that's not really something that needs to be shared in a transaction.
Well, hi there, Rachel. Thanks for joining me today to talk about data issues in M&A transactions. This is part of our data series for our bandwidth campaign. So should we start perhaps talking a bit about the actual process of getting ready for a sale and the issues with what data you might be sharing as part of that transaction or the due diligence process that's going to happen as part of a buyer or an investor actually proceeding with a transaction.
As you say, when sellers are considering selling the business, personal data isn't at the forefront of their minds, which is quite difficult when we then get involved and we have to try and explain that you have to really look at the data you hold alongside everything else in the transaction. So there's personal data around suppliers, customers, consumers, employees, and this is all within contracts, it's within other documents, it might be in policies, and that's something that sellers really have to think about before they go and provide all the information to a prospective buyer or an investor. There is an inclination of sellers to just give everything to put their best foot forward, but that's not always the better approach to take. It's better to just give what you have to give and then take a look at actually what does a buyer or an investor want to see in terms of data.
Yeah, absolutely. Because it's not always a given, is it, that they're going to need to see the personal data. They might want to see the underlying document, but not necessarily the data. So one of the areas that you mentioned there, which can often be quite commonly shared, is employees, isn't it? So employee data, organizations often collect and use a whole heap of information about employees in their business. So what are some of the issues associated with sharing employee data in particular?
So when it comes to employee data, it's not just names and addresses that companies hold. They've got health information, they've got racial and ethnic origin, which is quite sensitive data that you need sort of a better legal basis. You need a different one. You can't necessarily rely on consent, for example, in the employee context. And that's not really something that needs to be shared in a transaction. There's no need really for example, HR documents to be shared around other than generic policies. What we've actually started to see since the introduction of GDPR is that now sellers are just giving us generic templates for employment contracts or contracts for directors or consultancy agreements, for example, which is much better than going into a data room and seeing all of the employee contracts, because it's so much personal data that just doesn't have to be shared. You can provide salary bands, how many people in each role. We don't have to know who's in each role, who's earning what amount, who's got any health issues. So just getting generic templates to get the really key terms is a much better way to go about the exercise.
Yeah, absolutely. And so another key issue from a data protection perspective when you're dealing with data in an organization is transparency, isn't it? Being clear to data subjects about how you intend to use their information is kind of one of the key tenets of data protection law. So in this context, Rachel, what are the issues around transparency when you're going to be sharing some information about individuals in a due diligence process?
If sellers come to us initially and say, we're getting ready to sell our business, what should we think about? The first thing we would say in terms of personal data is check your privacy policies that you've given to everyone, not just your employees, but it has to be any that are consumer facing, if it's a consumer facing business, if there's any that have been issued to suppliers or customers. Because in these privacy notices, ideally what we want to see is something that says, we might share your personal data if we're thinking about getting more investment in our business or if we sell the business, because then they've been open and honest with the data subjects, which again, as you've said, helps with transparency. And it's quite difficult if they've not did that, because a business isn't going to want to go to employees, for example, and say, we're thinking about selling the business, never mind in a personal data context. And when they're asking to share their personal data, it's hard to get consent from employees because the relationship isn't balanced. So employees might feel like they have to say yes when actually they might not be comfortable with it. So if it's covered in a privacy policy and employees, for example, are already aware, that's much better for the business.
Yeah, so key here is really getting ready from a transparency perspective well in advance of actually proceeding with a transaction so that you clear to all the data subjects involved. Absolutely. Okay, so now let's shift. We've been talking a bit about the issues around preparing for a transaction and sharing personal data through that process. If we now look at what might happen if you're a buyer or an investor and you're going through the process of doing that due diligence and you identify some issues with data protection compliance in a business, what are the options, Rachel, that a client would have in that kind of situation to deal with those kind of issues? What can they realistically do?
So there are really two options. They can ask the seller to remedy some or all of the non-compliance pre-completion, but it is quite difficult sometimes to get a seller to do that. It might impact the deal timeline. There might be deadlines that just have to be met for whatever reason, depending on the circumstances. It might also impact the price if they want them to do it pre-completion. Similarly, the other option is that they do it post-completion themselves, which again might result in a reduction of price for the seller. What we often see is if the seller decides no and the buyer says, okay, we'll take the risk afterwards, it doesn't always happen. So if they decide to sell the business in 2 years' time, the same gaps are going to come up and then it might still be on the new buyer to remedy it 2 years down the line.
Yeah, absolutely. So making sure that if you do make that decision that you're going to remedy things yourself after you've bought the business, you actually do them and don't leave them is pretty key here. Absolutely. Okay, well, thanks very much for your time, Rachel. Really interesting topic, isn't it? Data issues in M&A transactions. And as I said, it's part of our data series on our bandwidth campaign. Really appreciate you taking the time to talk us through that.
No problem.